to today's event, The Importance of Judicial Training in Protecting the Rule of Law. Thank you for joining us today. My name's Alex Just. I'm a senior consultant and barrister at Montfort Communications, and I'm going to be chairing today's event, which is being hosted by the Better Justice Association and the UCL Judicial Institute. Before I introduce our speakers, I just want to give you a short introduction about the research paper which has inspired our event today. The Better Justice Association, led by Mehmet Gun, is an NGO based in Turkey that has developed a range of innovative solutions to pressing rule of law issues. Last year, the organization published a white paper which went into detail on a number of different themes. Some of you may have already watched webinars which have dealt with some of the structural reforms that the BJA think can and should take place in order to improve the efficiency and service levels of legal systems around the world. But today we're very much going to be looking at another element that's central to the BJA's white paper, which is around judicial training. And we're very, very lucky that we're joined by a world-class panel of speakers today. We have Dr. Patrick O'Brien, who is the Senior Lecturer in Public Law at Oxford Brookes University, and Dr. Sarah Razai, who's a Senior Researcher at the UCL Judicial Institute. And they're going to be taking us through some of the different approaches to judicial training, looking first of all from a common law perspective, which is where Patrick has done a lot of his research work, and Sarah will then be talking about the different way that judges are selected and trained in more continental systems based on the research that she's done in both Europe and then the MENA region. And we will then hear from Mehmet Gun, who will give us an overview of what the Better Justice Association have proposed in their work. There will be an opportunity for people to ask questions. If you do have any questions during the event, please put them in the chat box on Zoom, and I will do my best to put those points to the speakers when we get to our open discussion section later on today. So without any further ado, it's my great pleasure to hand over to Dr. Patrick O'Brien, who will introduce some of the key themes and really give us a flavour of why judicial training is so important.
Thanks so much, Alex, and thank you to the Better Justice Association and the UCL Judicial Institute for asking me to speak today. What I'd like to do in the time I have is give everyone a sort of an overview of how people are trained to become judges particularly in the UK and slightly in common law systems more generally. Now, because of the way that we select judges in common law systems, a lot of the training happens at the practitioner stage. When one doesn't start off as a judge, one starts off as another form of practitioner. Traditionally, barristers who were the people who appeared in court, but now a much wider range of professionals, solicitors who would traditionally have done the out of court work, so sort of family law, property law, that kind of thing, conveyancing, that sort of stuff. So a lot of what happens at the professional stage. And this entails that a lot of things that the themes that we're engaging with today to do with the rule of law, judicial independence and things like that actually happen before you ever become a judge. They are part of the ethics of the bar. They are part of the sort of the social aspect, the cultural aspect of what becoming a lawyer is. And people who are selected to become judges later on bring this with them. Traditionally, so there would be no training for a judge. One would be appointed, let's say, to the High Court, and that would be it. You'd be left to your own devices. Now, traditionally, of course, here means sort of 40, 50 years ago and previously. And the idea really was that the judge is a neutral arbiter, doesn't particularly bring any specialist knowledge to bear on the proceedings, and anything that is raised in court is raised by the lawyers for the parties. So the judge's role is that of referee. And to be a referee, you need to know fairness, you need to know your role in the system, you need to be able to speak law, if I could put it like that, but you don't need to know details about the facts. You don't need to know details about the parties or the specific area of law, because all of those are supposed to be explained in an adversarial format by the parties in front of you. There would be some specialism, So you would expect criminal lawyers to become criminal judges, commercial lawyers to go to commercial courts, that sort of thing, but not much more than that. And in theory, once you get to the more senior courts, high court and above, any judge can hear any case. As an eminent legal historian puts it, protection of the rule of law, judicial independence in this kind of situation is significantly by tradition. We have a tradition of the rule of law, we have a culture of the rule of law, and that's the way that we sustain it. Now, actually, the modern justice system in the UK and in other common law countries doesn't really look like this that much anymore. The role of the judge is much more managerial. There will be, for big cases, there will be planning sessions. We'll work out what's going to be admissible, what's not admissible. Admissibility rules will be set by very detailed court procedural rules, which are increasingly a feature of life. There will be planning of the timeline, what will happen at what stage. There'll be schedules for exchange of documents and so on. And we increasingly see specialist courts. A centerpiece of this in London is the Commercial Court in the Rolls Building, where people from all over the world come to London to give British lawyers lots and lots of money when they want to divorce their wives, for example, or sue people for defamation. So there's lots and lots of money in this, which it sort of supports the specialization to some extent. But we also see specialization in other ways in specialist family courts and increasingly a detailed tribunal system handling issues like immigration, employment law, and this tribunal system would traditionally have been part of government departments, and post 2007 are now part of the judiciary. So we have gone from a judiciary that was relatively small, relatively amateurish is not the word I would want to associate it with, but non-specialist, to one that comprises way more people, thousands more people, and is very specialist in some areas. But we still have the overarching idea of the generalist judge, the judge who knows what he or she is talking about before arriving on the bench, and is equipped by culture, training, practice at the bar to do whatever it is that they would need to do as a judge. And this is where the training comes in. So traditionally, you would have been left to your own devices, left to do what you want when you're appointed a judge. But gradually, over time, training has been coming in. The first Judicial Studies Board was established in 1979. This actually was a source of great suspicion amongst the serving judiciary, who were very concerned that this was going to be a vehicle for executive takeover of the judiciary, collapsing the independence of the judiciary. A lot of judges regarded even the idea of training as a breach of judicial independence. How can anyone, even another judge, tell me what to do, tell me how to run my court? Because another point we could just perhaps come back to later is that the idea of judicial independence in the UK and in common law systems is traditionally about the individual judge. You're not just independent from the other parts of the state, you're also independent from your colleagues on the bench. This, again, is something that is increasingly dissolving. We are seeing more managerialism and more training. Training has gradually been accepted because it was run by judges. Over time, judges came to see it that it wasn't a backdoor for control by the government. It wasn't senior judges telling junior judges what to do. They've come to regard it as quite helpful. And actually, interviewees we've spoken to, judges we've spoken to, say that the opposite is now the case. Judges will complain if there's a big new piece of legislation and they aren't given training on it. So judges now have an expectation that they will receive training on practice and procedures when there's big new areas of policy, big new areas of law. And I think this forms part of more general moves that we see even outside of the court, outside of the legal profession, moves towards more regulation, more accountability, the idea that training in professions will be a lifelong thing, a continuous performance-based thing, rather than something that happens at the very early stage of your life and then drops and you just expected to wing it from there. Now, as the law as it currently stands, the Lord Chief Justice, who's the head of the judiciary in England and Wales, and the Senior President of Tribunals, who's the head of the tribunal system, which, as explained, is now within the courts, have legal responsibility for training the judges over whom they have authority. They have set up what's now called the Judicial College. That was set up in 2011. This is now led by a senior judge, currently Lady Justice King of the Court of Appeal. And the Judicial College runs a lot of training courses for judges in a wide variety of areas, induction courses on the business of judging, judges as a communicator. And it publishes skills-based material, experiences of other judges, and it just sort of facilitates conversations between judges within the judiciary about how to handle various different forms of new legislation, new forms of practice, new phenomena. An increasing phenomenon in the UK legal system is the unrepresented litigant. So how do you handle someone who comes into court without a lawyer, who can't afford a lawyer, doesn't wish to hire one, and an awful lot of court resources and training resources now are dedicated to working out how to deal with and what's best practice in this area. So there's a lot of emphasis on accountability, on best practice. Former Lord Chief Justice described judicial training as a great success story in recent years. It's regarded very much as a positive thing. So connecting this back to the overarching theme today, which is the rule of law and judicial independence, I think it's probably worth noting that most of the training that I would be seeing, that we describe happening in the Judicial College, happening for the judiciary in the UK and in England and Wales, is not really about judicial independence and the rule of law. It's intimately connected to it because it helps the judicial system, the court system, to function correctly. It ensures that litigants and people who encounter the courts are likely to have a better experience than they might otherwise have had. The phenomenon of the sort of the grumpy old judge who can't be dislodged and everyone, just doesn't want to come before is less, and I wouldn't say it's completely gone, but it's less of a feature of the system than it once was. There's a general openness, I think, to learning new things, making things better. But if I had to reflect on it, I would say that a lot of the hard work of defining judicial independence, defining the rule of law, building up cultures in that respect is done before people ever become judges. It happens at the training stage. It happens at the practice stage. And in that respect, judges, I think, probably still come to the bench fully formed. And I think that would be the takeaway I have from this, that it's not exactly something that you can train. There's things that you can do, and training is participates in judicial independence, the rule of law, but it's significantly a cultural thing. And if we look at sociological data on judicial independence, what that says overwhelmingly is that the rule of law and judicial independence are protected by culture, not by law. So what we need to do is to build up a culture of judicial independence. New law doesn't do it by itself. And that might be a useful place for me to stop, although I'm happy to talk further if anyone has any questions.
No, I think that's very, very helpful, Patrick, just to set the scene. And now we'll hear from Sarah, who can give a perspective on how other jurisdictions approach this tricky question of where you find judges and how you get them ready to play an important role in civil and criminal legal systems. Sarah.
Thank you, Alex. Thank you. And thank you, Patrick. That was really insightful. And I have a couple of questions that, I hope we'll be able to discuss a bit later. So I'm gonna take it from the other side, essentially, and I'd like to cover at least two elements that are central to training, for judicial training. So the first one is training intended to kind of institutionally socialize individuals into a judge, into becoming a judge. And the second aspect I'll talk about a little bit as well is the post-appointment training. So once individuals become judges, what available training exists after that? And does that, help with the judicial function and, broader questions of the rule of law and judicial independence? So in terms of socialization of judges, particularly in the bureaucratic model. So Patrick was talking about the professional model, which is a very it's a unique characteristic of common law jurisdictions. So judges have already practiced law before, and they become judges afterwards. Whereas in the bureaucratic model, which is often represented by continental European countries or civil law jurisdictions, and obviously many societies in the global south, the bureaucratic models tend to recruit members into the judiciary with little or no prior professional experience. So candidates, they enter the competition, so it's often a public competition, shortly after graduating from law school, and they're selected through written and oral examinations aimed at testing their legal knowledge. Now, this type of socialization in theory is achieved almost exclusively from within the institution, right? So you don't have extra experiences prior to entering into the judiciary, which kind of presents a different view of the judicial role in bureaucratic models or in continental jurisdictions. Young candidates upon entry will learn the required norms and approved organizational behaviors in order to effectively participate within the judicial institution. Candidates are often placed at the bottom of the judicial pyramid and are regularly supervised by senior judges who exercise a degree of power actually over their professional status of the young judges. And professional training and experience are often acquired within the judicial organization, where judges are expected to remain until retirement. So that's kind of the model that we have. In contrast, and what Patrick was talking about, the professional model, entry into the judiciary is usually confined to individuals with an extensive amount of prior legal knowledge, or not extensive, but prior legal knowledge, or prior legal professional experience, which means that those who become judges are often at the middle to the end of their careers in legal practice. Now, although a degree of re-socialization occurs for members of the professional model, they're more likely to bring in values and experiences from outside the judicial institution into their working life as judges, and continue to maintain ties with their former colleagues in the legal profession. So these two models, essentially what they're suggesting is different approaches to socialization and also through training as well. And we're seeing nuances that really need to be taken into account when we're looking at the importance of training and the broader questions of rule of law and judicial independence. With regards to training in particular in continental jurisdictions and in the MENA jurisdictions as well, you have the acceptance of an individual's application to become a judge is not always unconditional and may not guarantee direct entry into the judiciary. And judges tend to undergo a probationary period after appointment, and education or training, so specialized judicial training is mandatory for new recruits. And while the training differs across jurisdictions, they tend to have similar features of, for example, senior supervisors who will kind of show the ropes to the young recruits. So that's kind of that's the very specific thing about a bureaucratic model. Okay, so in terms of how do we promote the rule of law? The second element is judicial training post-appointment. And we're seeing this now, particularly in the 21st century, following the pandemic, with a lot of digitization of justice. We're seeing a greater need for more extra legal training of judges. So if we're looking at the European Judicial Training Strategy of 21 to 24, we're seeing that there's a lot of emphasis now on operational objectives, tailor-specific training for particular judges as well. They tend to target a wider audience. So they tend to train judges to target a broader audience, which means digitization, it means dispute resolution. So there is a bit of emphasis on the extra legal knowledge that judges are required in the 21st century that is being emphasized upon. So on that note, I think I'll stop there. However, I'd like to, I'll go back to to some of the questions that I have, particularly with regards to the rule of law being supported by culture and not law, which I think is an extremely important thing to discuss, and which was what Patrick was talking about. Because yes, the rule of law is very much a culture that needs to be supported. It's not something. It's the responsibility of society as well as the judicial institution. And yeah, I'll be happy to elaborate on that later.
Thank you, Sarah. And now we're delighted to hear from Mehmet Gun, who is going to, I think, deal with that point about culture by talking about some of the specific proposals that the BJA have developed in respect of judicial training, many of which come from Turkey's long and quite distinguished history of really nurturing and cultivating judges and having them as important parts of the political and legal system. So Mehmet, over to you.
Thank you, Alex. Thank you, Sarah and Patrick. It's a very nice presentation so far. What Patrick said is about the culture to protect the rule of law and defend the judicial independence is a culture thing. Yes, I agree with that. And every nation has a system that has developed one way or the other, but they are not at the same level. So the culture, the achievements in these regards differ from one country to the other. But the human nature is the same all over the world, everywhere. Yes, countries adopt different systems, like Turkey follows the continental system and mainly follows the German and French system in its state structure. And the common law differs considerably from the continental law system. But the nature is that, you know, in every profession, in everybody's life, we have different stages. And the stages are the learning stage, and then practicing stage. And practicing stage can be divided into, you know, practicing with authority or practicing by learning. And then the last stage maybe could be divided into two stages also: excelling in what you're doing and also mentoring the others for them to learn, etc. So when I start from Turkey's ecosystem of judges and other jurists, I have to acknowledge that the rule of law is the end product that we need to deliver to the society. So my first aim is, you know, ultimately, the judiciary should be able to deliver the rule of law in the country, although it is not entirely upon the judiciary to do that, but the judiciary is the most important, factor in realizing that. And secondly, judicial independence, yes, it is really important in order to establish the rule of law, but judicial independence for me is, you know, a very important and probably the first condition of quality service in realizing the rule of law. So my aim would be to actually create an organization that, you know, manages number of thousands of people to achieve these two important end products. For this one, I have to recognize my country's own, ecosystem, and in this ecosystem, we follow, how do you say, comparted, sections. Education is different. Training is another difference. Then exercising is another difference, and the promotion through the career plan is another thing. Our question that we were trying to solve was actually create the judiciary a system of, thousands of people that provides quality service to the judiciary, and the first quality condition being the judicial independence. So we thought that maybe to reach to the same level that the judges are appointed from among the practicing members, maybe private practices, we need to develop the careers of judges, prosecutors, and private practitioners in a uniform, according to a uniform career plan. So for this one, we said, anyone coming out of the law school in our country's conditions, we have already admitted that the quality of education is not good. So we need to, make sure that they are suitable and eligible to enter into this profession. And then from entering the profession, then we need to allow them to make informed decisions. People at the age of 23, 24, 26, maybe some of them are 23, 22 sometimes, they're unable to decide accurately for their future and also where they are going to be most helpful. So we give them the right of 1 year as kind of introductory training so that they get to know all these different judicial professions. And then they choose the profession they like, and they get formal training for 1 year. Again, still they are too young. So we take them through a sort of reporting professional position so that they get to report, they get to learn about the experiences without getting involved in the profession, in the exercise of the profession. Once they have had enough exposure, then we promote them to become an assistant judges, prosecutors, or lawyers so that they help the practicing members. This is in reality because we recognize that the profession is actually a kind of profession that we need to learn from, the more senior, more experienced people. So we value this, and we create opportunities so people, younger people, inexperienced people get together with the experienced and older people so that they get to learn about the life and about, how to exercise the profession. Until after this, according to our proposal, no one is authorized to exercise these professions on its own. But after going through this, having succeeded in the exams, then they're entitled to do that. Once they're admitted to the legal profession, again, this is a compartment style management of judicial system. Within that compartment, we have different compartments. We have the idea following the court system. We have first instance courts, then the appeal courts, and then the court of cassation. So this structure has already been established. We do not propose to change this structure at all, but develop the human resources accordingly. So once someone is admitted into the profession, then we actually encourage them to improve themselves in order to be promoted. The independence of a judge is really important, but motivation is also very important. So we cannot really tell a judge that you have done bad job. We cannot reprimand him, but we need to encourage him, to do better and better. So, and measure how they do, and if they do not measure good, then we actually help them to improve themselves. So we have introduced a 3-layer system. In this 3-layer system, they are encouraged to do academical work as well as practical work, and try and excel in their positions and show good performance, and thus be entitled to promote to higher places. Again, one of the higher ideas is that if a jurist has been able to reach to the level of, Court of Cassation level, I'm sure we would have thousands of them in, 5 or 10 years time if we manage it very well. Then they should be the ones teaching law in law schools. I know that in the UK, law schools, prestigious law schools, Oxford and Cambridge, have been, have their roots in barristers in London. So without really realizing the, what's the real life, really understanding, why people make the rules and how they would like to be managed according to those rules, then it is, it becomes an abstract thing for, law schools to teach their students. They simply, get them memorize the, statutory provisions, and also teach them how to, interact these rules together. Instead of that, we propose that, people coming from the practice advance themselves to an academical level, and then start teaching as well as practicing, so that the teaching of the law and the practice are aligned. So therefore, judicial training and performance of judicial people are really important, but they're not. They cannot be separated from each other. They need to be, performance assessed. We have 4 core areas for their performance assessment. One is that obviously professional competence. They need to have that competence. They need to have the skills to do their job. And the second one is the social competency. They need to be recognized as judges, and they need to be respected, so they should be able to deal with people that they are going to interact, either with their professions or ordinary public. They need to be, again, one of the conditions for judicial independence is a sort of personal recognition by the society. So personal traits, they need to be assessed, as well as quality of their service should be assessed. We have studied the German system, and I think they have quite a good performance system. But the training should be offered in order for the jurists to actually improve themselves on these 4 points. And these 4 core points relate to the quality of legal service. So we are proposing that they should when passing the 3 different degrees, they should go through oral and written exams. They should the feedback by the society and by their colleagues should be collected, and also a kind of 360 degrees appraisal system needs to be put in place, so that A, jurists are able to perform properly, and B, people are happy about it, and C, they are told what they need to learn. That about the specialization aspect, I would like to talk maybe in the second round, but this is basically the skeleton of our proposed training, performance management, and career system.
Thank you very much, Mehmet. And I'd like to start by just asking all the panelists to consider, because you've all touched on this a little bit, the way in which judicial training in different jurisdictions sort of weighs the importance of legal and extra legal factors in the training. Do you think that in an increasingly sort of polarized world, judges are having to be given more advice in how to deal and think about things that are happening outside the court, as much as traditionally their role was to just think of things that are focused in the courtroom? Patrick, I wonder if you could start us off on that one.
Well, I think there are 2 aspects to that. The first is engagement with the outside world. And then the second is maybe softer skills or socialization, as Sarah very elegantly put it. I think that's a really useful way to put it. In terms of media skills, we are seeing training on that for judges. But I'm not entirely sure that it's true that judges were never participating in that. I think more self-aware judges that you'd speak to would say, well, of course, my job is to know what people on the street tend to think about things, because there are times when you do need to consider that in terms of, say, sentencing. How do you assess the gravity of a crime? Well, in part, you assess it by reference to social norms, and you can't be someone completely removed from society and be a good judge. But this, of course, leads into more difficult territory about pressure being put on judges and how sensitive should they be. And I think this connects then to the informal part of training. And in common law systems, and particularly in England and Wales, we have a system of inns and sometimes chambers, whereby to be a member of, focusing specifically on the bar, to be a member of the bar, you've got to be a member of one of the inns in London. Part of the training involves sort of going to dinners and listening to lectures. And so there is a sort of an inevitability about being socialized in the law. Those who practice at the bar, who practice in solicitors' firms, practice in a collegiate way. They ask each other for advice and so on. They will have access to more senior people to model their own practice on, but also to get more direct kind of feedback from. So that process of socialization is almost compulsory. It's built into the structure of training, the structure of the system, before we even get into the content of education. After you get onto the bench, then the extent to which you engage with the outside world is sort of a matter for you, but I don't think you can be a good judge without doing it. Judicial criticism then in the media is another issue that perhaps we can get onto, but that is something that judges get training on. There are increasingly good sort of media and social media operations that the judiciary run to try and deal with some of those aspects, but that's going slightly off on a tangent there, so I'll stop there.
Yeah, I wholeheartedly agree with Patrick, and with regards to the indirect training, which I think is a very unique and actually a really good feature of common law, particularly in England and Wales, where you have, you increase as a judge, you increase your chances of perspective taking, which is a core function of the judicial role in my own opinion. And I think, your question, Alex, bleeds into the question of what constitutes, a judge. What is the role of the judge? And here, we go into territories of is the judge just a mere executor or a mere mouthpiece of the law, or should he or she be a bit broader and maybe even be considered as a guardian of the community in certain instances? And this is a very controversial, very hotly debated topic within judicial studies. Is that okay? What constitutes the role of the judge, and if so, how does that relate to the broader social and political system? And I think, in my opinion, I think a judge is not a mere civil servant and is supposed to apply the law. No, particularly with human rights discourses, what we're seeing with the current climate, judges need a greater role. But where do we draw the line on that? And I think when it comes to judicial training, we're seeing based on my research in particular, and the judges that I've spoken to in the MENA region, we're seeing that they definitely find strength in their role, in their function, when they have opportunities for training, for example, even post-appointment training. So we're seeing a lot of Arab judges coming to the UK or France. They're doing their PhD studies, they're on secondment. And all of these indirect training strategies really does strengthen the role of the judge. I'd also like to pick up on something that was said before about institutional independence and individual independence. So as Patrick said, individual independence is kind of more emphasized in common law jurisdictions, whereas in continental jurisdictions, you have the institutional independence of the judiciary. Judiciary vis-a-vis other political institutions or vis-a-vis society is supposed to be uniform and autonomous, kind of immune from the day-to-day turbulence. And this has some historical roots, particularly in France. But we need to ask ourselves, okay, is this institutional independence good for society and good for the furtherance of the rule of law, whatever the rule of law means, right? That's also a different concept. So yes, we need to ask ourselves, okay, if we adhere to institutional independence, what are some of the problems relating to judicial training? How do we make the judge more in tune with the social mores, with the political factors, elements, etc. And they're not immune, and it's unrealistic to say that they should be immune. And we've seen that. We've seen that in many contexts. Yeah.
Mehmet, linked to this, we've had a question come in from somebody watching, which is linked to this. To what extent do you think that judges, and through the research that you've done, there's a perception in the sort of business community, I suppose, and for the users of courts, the judges need to be experts and specialists and really understand the framework in which they're operating. Because as Patrick said, there is some tradition, at least in the UK, that somebody's been a practitioner, maybe they've worked in the family courts for a long time as a barrister representing parties in family cases. When they then become a judge, they do have some level of expertise. In systems where you're recruiting and appointing people at a much younger age in their career, they don't necessarily have that exposure to the cut and thrust of the corporate world or the ins and outs of family, different types of family relationships. So how have you assessed that difficult question of how much technical expertise judges really should have?
I should maybe convey the messages that I hear from the business community. I have been touring Anatolia, and I have conferenced with maybe hundreds of businessmen around the country. What I hear common in those communities is that two things: is that what is the role of the judge? They say that the judges and the lawyers also as a sort of piggybacking on the business community without creating value, which I tend to agree with them. I think we're not creating value, but we're taking some part of the value that the business community is creating. That is not fair. They say, what is a judge's role? Is he a representative or a ruler that makes a decision and we have to obey with it, whatever it is, be it right or wrong or inaccurate? Or can we have judges as our guides? I mean, lawyers are more guide types, but the judges are more, rulers' representative. So, what is the judges doing actually? A businessman told me, and the same question was asked a couple of other times also. He said, if I have a receivable or if I'm entitled to an indemnity, then I need that indemnity within a year or so, not longer than a year. It doesn't make a meaning to me if it is too late. But when I go to the judge takes so long that in order to find the most accurate conclusion, that I suffer at the end. And nobody gains anything, but I suffer at the end. He said he would prefer the judge to make a rough decision very quickly, and then he would prefer to go and settle with the other party. I think this is what the English courts are really good at, because they force people to settle very quickly. But the other businesses, especially businesses moving towards cutting edge businesses, they say, our businesses is so different. Nobody understands the particulars of our business. So talk about a large, swindling or what's the word? Infidelity in a broker company. There's millions of dollars worth money has been stolen in a couple of cases. Justice cannot be delivered. The judiciary, before they even start, the monies have left and maybe toured the world a couple of times, so that you're unable to trace it. So they say in Turkish business community, especially, they say that they need to be specialized. They need to be specialist and be aware of the particulars of our cases. If it is a maritime case, the judge should better be a captain, understand the effect of the wind, affecting the how do you say the course of the ship. Or if it is a financial case, then the judge should be really familiar with how things work in brokering institutions, etc. So we are seeing this kind of development of the judicial system. I think in German courts they have non-jurist judges in patent courts, because patent cases are really technical. In order for judges or for jurists to understand, it is so difficult that myself, I do a lot of patent cases in Turkey. I have to work with several academicians in their field. So the business community says the judges should be familiar, at least, in order to deal with our cases. But on the other hand, there is another thing that goes down to the core of the issue, is that what is justice anyway? What is rule of law? Would be better to talk about fairness instead of justice? And the rule of law, well, it's a nice word, I like it. I like using it, but what is rule of law? And we have politicians that walk from Ankara to Istanbul saying we want justice. But we have general public say that we want justice, I want justice, but the case needs to be finalized in my favor. So what is it? So I think as jurists, we have a lot of questions going down to the question of what is the role of judges and jurists. And I think that we need to make the whole judicial system as guides for the society, that helps them to settle their differences, create richness out of differences and clashes, and help the coherence between people.
Thank you, Mehmet. Patrick, from what you've observed in the UK, you mentioned earlier some of the more technocratic elements to the way judges are now being trained and developed. And obviously, in recent years, there's been some specialist divisions that have been set up. Specifically, there's now a media and communications list, which is a separate division of the High Court that's currently sort of headed up by Matthew Nicklin, who was a very high-profile practitioner in that area of data and privacy and defamation law. Do you think that's a response to some of the feedback that Mehmet's hearing from some people, court users, from people in the business community who actually want to have experts? This idea that you can just have a very clever, wise, older person sit and adjudicate without really understanding the world, given how much more complex things are, whether that is in intellectual property disputes or in a data protection case. Are you finding that there's a trend amongst the way that judges are trained and indeed given specific roles to match their skill set a bit more closely with the areas of law that they're adjudicating?
Yes, I think perhaps not as a function of training, but perhaps as an outcome of their prior specialization in practice, as you said. There are lots now of particular lists. So there's, to use the example Mehmet gave, there's a patent list as well within the commercial court. I think one needs to be careful about expertise in the common law system, because I think still the ideology of the thing is that you won't be specialist, and that it is for the lawyers and the litigants in the first instance to bring the specific specialist issues before you and to make them make sense in the context of the law. And I think what specialist courts do, and particularly something like the commercial court, which in effect is a sort of a business offering, and from the courts in London that sort of subsidizes the rest of the system, because you have to have an awful lot of money to walk in there in the first place, and then you get specialist courts and streamlined procedures and all that, but you have to have an awful lot of money in your pocket, and your claim must be worth an awful lot to get in the door. But what that does for you is it gets a judge who is used to handling this type of case. So they will have some specialist legal knowledge, I suspect, in this area. They're likely to be recruited for that reason, but they will also build up knowledge of the kind of issues that arise in these cases, and it's likely to be fast-tracked. But it costs a lot of money. And I don't think that that can be separated out from that problem. We also had, as I mentioned earlier, we've got lots and lots of specialist tribunals dealing with very, very small parts of the law. So, there'll be specialist aspects of employment law, immigration law, where the same judges will hear the same cases the whole time. And that will build up expertise. But I think one has to be conscious of the fact that it won't be possible to have an expert that does everything. And I don't think we can rest the authority of the judiciary on the idea that they would be an expert in nuclear physics, for example, or how to captain a submarine or something like that. The role of the parties and the litigants in the common law system is to make the factual aspects of that make sense in the context of the law, to present a case before the judge that brings the law and the facts together in a way that connects to what the law actually is. And obviously the judge having expertise and experience and specialist list and all that, these things all help. But the authority of the judge is ultimately his or her authority to give an authoritative binding decision based on the law. And so I suppose what I would say is specialism certainly helps, I think, and it can help to streamline things, because an experienced judge is likely to see the issues and to be able to sort of schedule the various parts of a court process more effectively, see what the big issues are likely to be. But it's not going to be all of the story in terms of authority and in terms of getting to a decision quickly and efficiently.
Sarah, is the position different where judges have a slightly more, not activist, but maybe proactive role in the proceedings, where they're obviously, as in France, being more inquisitorial, having to take the lead in the fact-finding stage, as Patrick says? In common law jurisdictions, generally, the information is sort of presented up. But are you finding from your research that judges who are having to take on that greater role do now, or are expected to have a deeper understanding of what's going on in certain areas of commerce or society, so that they can fulfill their function effectively and kind of give people confidence in the system, which then feeds into this wider issue of people believing that the courts are fulfilling this wider objective, as Mehmet says, of justice, sort of upholding the rule of law and so on?
I think I would broadly agree with Patrick on that. I think there's not much difference in terms of, because we're essentially talking about the core, the universal function of the judge, right? Which is, yeah, you apply the law, you use the law as a basis, but how much you use that and how many extra legal factors you take into account, that is subject to debate. In my research, particularly in the continental systems and in the Middle East as well, you're seeing not a shift, but a gradual kind of coming together between the common law and civil law aspects of these. And also, I think in a very unique characteristic of continental jurisdictions is that the institutional makeup of the judiciary makes certain courts very specialized than others, if that makes sense. So you have administrative courts. So judges within the administrative court branch will be trained essentially in administrative matters, they will have specialized knowledge. And then we obviously have, security courts, we have national security courts and economic courts. So there is inevitably specialization within the legal system or within the different judicial pyramids. Other than that, I wouldn't say there is much difference, and I would broadly agree with Patrick. Yeah.
What have you as panelists found have been the biggest barriers to ensuring effective judicial training? Mehmet, I wonder if you could start in the sort of research that your team did for the A to Z reforms report. Did you identify anything that wasn't working as well as it could, perhaps, in terms of how judges are trained now? And then I don't know if Sarah and Patrick, again, if they have any thoughts on where some of the sort of blockages in the system might be.
I'm sorry. What we find is that any formal training on judges, lawyers, and prosecutors is going to be short. So you will never be able to, train them about all the things that they need to know. You will never be able to teach them nuclear law, and you will never be able to teach them the biologics, etc. So the idea of training them during their profession is bound to fail, to my mind. And secondly, the judge assuming the judge is going to find the most accurate question and is going to end up with the most accurate implementation of the law is, illogical to me. And I think we need to admit that the judges are going to make mistakes. And the best, the correct decision is what the parties agree upon. But when the parties cannot agree upon, what are we going to do about disputes in the society? And what are the roles of the judges going to be? And I think this is goes down to the core of judges' role is that we need to actually train them to actually ensure that the whole truth is brought before the court and the parties learn about it. And the parties are constantly incentivized, encouraged to come to an amicable settlements between the parties. Today in FT, I've read that a company called CureVac sued BioNTech in Germany, saying that BioNTech's technology on mRNA is actually studying on their earlier findings. How can you address this question? Because the BioNTech is led by a person who is the leader of this field. I think there are only 3 persons in this field as called authority. How they are going to be able to bring to the judge, and how the judge is going to understand and make the most accurate decision. But a judge can be sure that all the issues, all the information, all the facts have been properly brought before the court in order for an accurate resolution of the dispute. So, and hopefully, as it happens in the UK courts, the parties will come to an amicable settlement somehow. So I tend to agree with Patrick's description that the judge should not play too much role, should not try and become expert on everything. That is impossible. But the judges should be really important, really capable of establishing the full truth. Therefore, I find the continental system a little bit failing, Sarah, because there the principle is actually the judge is bound by what the parties have brought before him. And we can see that the parties making a sort of it's a collided effort to actually have the judge to make a decision in one way or the other. We have seen some examples in our country. In the continental system, there is another danger. I say that in every case, there are not only 2 parties, there are 3 parties. One is the plaintiff, defendant, and the judge. The third party is the judge. The judge, if the judge is given so much right to control what happens in his courtroom, then he's going to take care of his interests first, then the party's interests. So I'm going to finish with a comical story from Turkey. Sarah would be aware of Nasreddin Hoxha, an old figure. I think the story goes 4,000 years. He was serving as a Qadi judge in his town, and someone came as a plaintiff with the defendant and said, I have this complaint against this guy, etc. So the judge, Hoxha, listened to him and said, you're right, I rule in your favor. No, so he sends him away, and here's the defendant. The defendant says, blah, 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 blah. And the judge says, my God, you are right. So I rule in your favor. So he goes away, and the wife comes after the judge, the Hoja, because at that time the courthouses were their houses, and says, husband, what kind of a judge are you? You know, you say the plaintiff is right, you say the defendant is also right. What kind of a judge are you? And he turns to her and says, wife, you're right too. So I think this is a good example, a comical example about the role of the judges. I think we should try and prevent them from adjudicating on differences between the parties, but we should use them as guides that help the parties to actually settle their differences.
I'll thank you so much for that, Mehmet. The Hoja, you brought me back to my childhood. I remember reading the comical stories of Hoja when I was a child. Did not know about that story. I'm gonna say two things in response to your question, Alex. I think in my research, the two biggest problems is not problems, but things that we should be thinking about more is the indirect forms of training of judges, and definitely the rules of thumb and the informal rules that you see within the institution, within the judicial institution, that is quite insular from the outside. And this is when we're trying to enhance the function and the role of the judge, we need to look at it from a bottom-up, top-down approach, particularly in the continental system, because of the emphasis on institutional independence and that isolation I was talking about earlier. And I think the second thing, which kind of broadly connects to questions of the rule of law and rule of law by culture and not law, is, you know, there needs to be more of an emphasis on law and context. So judges need to be more aware of contextualizing the law in its particular context. That doesn't necessarily mean that you need to be an expert in nuclear law or whatever, but you need to be able to contextualize that law. And I think this is something that is increasingly becoming necessary, because law has become so, it has come into the, you know, it's not a unique thing. It is part and parcel of society. And I think judges ought to know more about how the law is perceived, or how it is practiced upon in society. So I think those are the two broad questions or broad concerns that I've come across.
Patrick, we just had a comment from somebody watching this who's making the point that the legal education model, in her view, should be based on a sort of Socratic method, with students asking smart questions as well as receiving information. Do you think that's that kind of culture of getting judges to be more proactive in the way that they engage with the sort of changing world and the way they view training, is something that's achievable, or is it something that people are striving to achieve in the conversations you're having, particularly in the UK?
I think that's a very broad question. I think in terms of Socratic method, I mean, there's a place for that in education, certainly. I think sometimes it does just have to be about content, though, and particularly in very, very, you know, we increasingly in common law, as much as in civil law, countries are seeing legislation that looks like code, even if it isn't formally code. And I think sometimes the solution is just to put in the work and learn it. My sense of what judicial training, once you're appointed, actually looks like is it's quite informal. It's, you know, judge who has dealt with this thing speaking to other judges. You know, it's meetings over coffee and things like that. So in that sense, perhaps it is Socratic. It doesn't tend to be particularly, as far as I can see, top down. They bring in external people to deliver specialist lectures on topics. But yeah, in broad terms, I think there's all sorts of different ways to educate. In terms of the courtroom, if we're meaning that judges should be more inquisitorial, or they should prompt litigants, well, actually, this is one area where we might be seeing the difference between common law systems and civil law systems collapsing a little bit, because judges, I think, increasingly are more interactive, and they're having to be, because so many more people are appearing in court without lawyers. And that's a whole different, almost revolutionary problem for the common law system, because acres of very, very specialized bits of legal documents have to be translated, repackaged, and this has to really be done by the judge for the litigant. There's constant emphasis on whether the litigant actually understands, whether they're actually able to continue the case. So at least in this limited respect, judges at the lower levels of the court system are having to be more like civil law judges, more inquisitorial. So there's all sorts of ways in which all these barriers are collapsing down. And if I could just go back to a lot of the previous points were about culture and so on. And increasingly, I think we're seeing more interaction between judges, particularly at senior levels, from other countries. And there's a sort of an international fraternity, if I could put it that way. There are lots of international societies and conferences that judges go to. And that also reinforces the rule of law, because it gives them a sense of kind of confidence, solidarity that they can take back to their own individual jurisdictions. And they get some of that too from the professions, and in the UK system from the inns. Going to dinner with serving barristers is a sort of a continuity there.
Thank you. I'd just like to, sort of wrapping this up, give everyone one last opportunity to say why they feel judicial training is really important in this wider context of protecting and strengthening the rule of law. Patrick's just alluded now to sort of changes to the legal landscape, and the fact that more people are having to come and are really looking to the judge to help guide them through the process. Mehmet, what for you made judicial training an important plank of the reform package that the Better Justice Association has been keen to publicize?
There are a number of aspects, but I guess probably the most important aspect is to actually, develop the practitioners in order to better cope with the workload that they're receiving. We have enormous workload, and we believe that part of the workload and maybe a bigger chunk of the workload can be avoided if the judges were more knowledgeable and were able to implement some of the information systems and the personal skills, etc. That would avoid probably going to the experts a lot, and also save from the length of proceedings. That's why we think that the judicial training is really important, but at the same time, it is important because we want the meritocracy to reign in the judiciary, and more capable people to advance more, and less capable people, less performance, need to be trained more to increase their performance.
Sarah?
I think, by necessity, right? Any social role, like the role of judges, you need continuous judicial training so that the role does not become archaic, and that it fits with the overall path we're moving on as human beings, right? So I think training is extremely important, so that questions of justice are always addressed accurately and with the adequate knowledge. Whether that, how training is done, I think that is very context specific, and it depends on the, institutional factors, behavioral, functional, but at the end of the day, training should always be a constant, regardless of jurisdiction.
Thank you. And final word today to you, Patrick.
Thank you. Well, just following on from what Mehmet and Sarah said, I think really training for me, looking at common law systems, is about the fact that the world has changed, actually. And we now, as a society more generally, we expect performance-based training. We expect for professions to be more accountable, and judges can't be immune from this. And I really enjoyed Mehmet's story example earlier, so I'm going to give one of my own. I think in the early 90s, a judge got into a bit of trouble in the newspapers because he said in court the immortal phrase, "Who are the Beatles?" In a court case that I think was about copyright law. And this was replied, oh, you know, the judges are all allowed to touch. This is ridiculous. But the point was that this was a perfectly sensible question, because the judge is not supposed to bring his own knowledge into the court. It's for the parties to establish the relevant pieces of information. And why is this relevant here? Because judges need to be more aware of the outside world, and training is a big part of this. The authority of a judge rests on the fact that they are able to be trusted, that they are able to perform at an appropriate level. And particularly in the societies that we operate today, we expect that authority to be backed up by training, backed up by judges not appearing to be these really alien, ancient creatures, and being something much more approachable and speaking in terms, even where they make legal sense, that also makes sense in wider societal terms. I think probably that's a fair place to stop there.
Thank you, Patrick, and thank you to Sarah and to Mehmet. This has been a very entertaining and very informative discussion. So on behalf of the Better Justice Association and the UCL Judicial Institute, I'd like to thank all the speakers, everybody who's joined in to watch this live, and we would encourage you to all have a look at the Better Justice Association's proposals in more detail. You can do that on their website. The easiest way to find that is just to Google Better Justice Association. And we'll be back later in the year with more discussions around various themes connected to the rule of law. But thank you very much for taking the time to join with us today. And we hope you have a good day, however much of it you've got left, wherever you are. Thank you.
Bye-bye.